7, a very good morning to you. This is Rise and Shine. Let's kick off this hour with South Africa news there. President Cyril Ramaphosa expected to learn his fate this morning on his court bid to halt the Parliament Impeachment Committee process against him. Ramaphosa approached the Western Cape High Court to ask the court to stop an impeachment inquiry against him over the stolen foreign money that went missing at his game farm in Phala Phala in Limpopo province. He is asking the court to stop the inquiry from commencing its work until the same court rules on his application to set aside the report that concluded he had a case to answer on the theft of about $580,000. A very good morning to legal analyst Mpumelelo Zikalala, who's going to help us unpack what is going to happen today and what the domino effect will be on just generally the whole impeachment process. Mr. Zikalala, Mpumelelo, a very good morning to you.
Good morning to you, and also good morning to your listeners.
So let's just first start with Section 89. I know this is at the heart of what is going on here. It's designed to protect the Constitution from a wayward president. But I think what is important for me and others to understand is what is happening now. At what point does this not become another arena of political contestation, and what point does impeachment also lose its constitutional character in the face of a parliamentary power politics game?
It's a very important question. Hence why we have a section 89 that deals with this type of issues, because the drafters of the Constitution knew that people that go to Parliament are political in nature. Their mandate are going to be politically driven and sometimes not legally driven. So let's create a platform in which one, even the complaint that comes through, is not one which is frivolous, but it is one which is so grave and contravenes the Constitution to such an extent that it warrants for this process to be able to begin. Now, the previous rules that were there as to how to deal with these issues was then set aside by the Constitution, and new ones have now been implemented. And part of those is to say, create the impeachment committee as it happened now, get the terms of references, get the person who's going to be the evidence leader, and then deal with the merits of what has been stated there, which is what the president is trying to set aside in terms of saying, you can continue with your process on your own, is fine. But when it comes to the merits, I do not want you to deal with that with them up until September, because I'm of the view that the merits have not been sourced in a proper manner. The merits have not been looked at in a manner in which it complies with the Constitution. So, which is why I want to set them aside. But before I go there and do that in September, stop your proceedings for the time being, so that I get an ample opportunity to deal with the allegations that have been leveled against.
It brings us to the aspect of what is political theater and what is evidentiary necessity, because the whole issue around the president needing to give oral evidence before the committee in terms of establishing the truth, how important is it, or is parliament in danger of falling into that political theater, as I mentioned?
Yes, it is, especially if it the arbiters, or let's call them the presiding officers, are parliamentarians themselves. It's like me being a parrot supporter and being asked to assess whether my opponent is doing something which is right or which is wrong. Obviously, I'm going to be biased towards my own own political party and own sports team that my allegiance is towards. Then you must then come back and say, how to insulate this. One of the ways, make sure that you've got a strong evidence leader that is only going to look at the evidence and end it there. Number two, make sure that the terms of references are up to par in terms of what is required. But the one flaw that you may get, and I don't mean to cast an experience on the members of parliament, is, do you have members that are going to sit on the other side that have got the ability, the acumen, the skill, and the education to be able to decipher whatever information which is going to be presented to them, which is highly technical and highly legal in nature, so that they're able to say, this evidence goes in, this evidence does not go in. This is the type of conclusion that we come to, and this is why we are saying that the president is guilty or the president is not guilty. If you don't have that, it means you are then causing this whole process after paying so much money to be a waste. I'll make reference to the ad hoc committee. Up until now, and I stand to be corrected, you and I do not have the final report that says who's wrong and who's right and who should be further prosecuted. Then the question is, were the people that were employed or deployed to that particular committee able to do their job? That's the question in which you must again ask within the parliamentary committee. Now, let's take a step back. What the president is now saying is, I don't even want this report to go to this particular committee because the way it is drafted or the way in which it is done, it does not conform with what the rules of natural justice would require. It does not conform as to what that particular committee was given instructions to do. The results of that is that you are going to come up with a conclusion which is flawed, and I do not want to go through a process of a flawed things that needed to be there. If they want me to hold me accountable, there are other ways and tools that are available as per the constitution that can be utilized in order for them to do so.
Just in terms of the operative word final that you mentioned earlier on, there is the other aspect that has been discussed in terms of weighing in on in which direction this case should go, and that is institutional finality. We've seen the response on the matter from the Reserve Bank, SARS, and other investigative bodies. So, in terms of what Parliament has to do, does that strengthen the accountability or weaken confidence that institutional findings are very truly settled?
Well, it does pose them to be a bit on the weaker side. If you do not trust what the South African Reserve Bank is saying to you, then the next process is for you to take it to court for a review of their decision, not to go to Parliament through the impeachment committee to then come back and ask them those questions. Reason being, once you've got the governor who is here, what type of questions are you going to ask the governor if you do not possess the technical skills to be able to decipher what is usually required when one declares all these things? Which is why, if you then go to a court of law, you have a legal practitioner that is able to assist you, has read the relevant piece of legislation in even case law, and is able to decide, was this done correctly, was this done incorrectly. It doesn't mean that whatever that we receive from our institution is correct. Hence why we go to court and their findings and decisions are sometimes set aside. But it does mean that if you want to challenge it, you must make sure that you have the technical know-how to be able to do that, so that you go to the nub of your complaint and take it from there. Yes, you do need an opportunity and a platform in which, if you are not happy with what these institutions are telling you, Parliament should be able to call them to say, come to us and let's deal with these issues as we move along, so that we can be able to decipher whether the things were done correctly or not.
So, in short, and you've pretty much been working towards this and you have answered part of it, but ultimately, can Parliament legitimately make findings on presidential misconduct while related legal disputes remain unresolved in the courts?
That's the question. But the short answer to that is yes. Remember, Parliament is on its own, deals with on its issues and submissions on its own. So it can sit, listen to evidence, and then make a finding. But I do not think that those findings would be taken lying down. Probably they would be reviewed, and then when taken to court, the one thing which is going to be asked, let's first check the methodology that you've utilized. What did you look at? What tools did you look at? Is it a decision which is based on emotions, on rationality, or is it based on the law? Let's look at that and then we'll take it from there. If we do not, though, put stops and balances and precautionary measures at the start, it then means you are going to waste a whole lot of time and money discussing things at the end of the day in which you are going to be found by a court of law to say, well, you did not do your job properly. There are many things that didn't go very well in this matter.
Thank you for your time and your insights. Legal analyst Mpumelelo Zikalala speaking to us about that Phala Phala court case before the Western Cape High Court. The outcome expected later on today. President Cyril Ramaphosa waiting to hear his fate. Brings the time to just about 20 minutes past 7.
Be inspired. Stay informed. Channel Africa